I'm going to try to start right on time today because I got a lot to cover. So, and it's actually one of my favorite lectures to give, so I kind of get into it a little bit. But I actually did something a little different today. I attended a lecture last Friday. The faculty had invited a guest speaker who talked about effective PowerPoint strategies. And really the focus there was really getting the slides down to as minimal as text as possible. So this is a bit of an experiment with that. I'd like to get your impressions afterwards because it is very conventional in law school to have like these dense slides, that you get in advance or you might want to print out afterwards. So I'm going to try something different today, in part because what we're doing today is really about getting a theme across to you and about exploring concepts as opposed to necessarily dealing with some very sharp black letter law or lots of black letter law. But yeah, I'd love your feedback. I worked hard to revise this because I really enjoy this material, and I'd like to know if it's more or less effective this way, and I'll keep trying to, always trying to step it up. So today is about corporate social responsibility, and we've been talking about corporate social responsibility in one way or another since we really began the course. But today we're going to really drill down on the three core concepts in the concept of corporate social responsibility. And we're going to talk about who does the corporation serve? Is the purpose of the corporation to serve society at large because it exists at the pleasure of the states? It's a synthetic entity that we're permitted to create because of law. And should it then serve the purpose of that law, however we construe it? Or is the purpose of it to serve the shareholders? And the divide between that are going to be what we call shareholder wealth maximization, or SWM. And SWM, or shareholder wealth maximization, is the concept that the board of directors has an affirmative duty to always be focusing on the bottom line, always be looking to increase the stock value of a publicly traded company, increase the returns to the shareholders. But as we'll see in our first set of cases, that's actually not even that clear on its own. What does it mean to maximize value? Does that mean maximize short-term value? Does that mean to maximize long-term value? Does that mean to take huge risks at a chance of a 1,000x return? Does it mean to minimize risk to make sure you get a 10% return? What exactly is the board charged to do if we can even agree that their only charge is to maximize shareholder wealth? And then the other aspect is that they're not supposed to maximize shareholder wealth at the expense of all else. They're authorized, maybe obligated, to also pursue corporate social responsibility. That might mean charity. That might mean choosing eco-friendly products. This means, in general, making choices that are not about the bottom line, not about profitability, not about the shareholders, not about value, at least ostensibly, but are really about making the world a better place for others. Now, those others could be shareholders themselves if they live in the community, but it could also be employees or even just stakeholders that have no other connection to the corporation other than it plays a role in their lives. So we're going to talk about the classic case of Dodge versus Ford Motor Company and the meaning of that case to really try to understand these concepts a bit better, talk about corporate charity under corporate law, and the role of directors and officers and the lawyers who advise them in making those decisions. So our first question is whether or not corporations should be understood as private property, like your home. You can put a gate outside your home. You can use your home for any lawful purpose. The nature of property is that you can prohibit others from using it. That's your exclusive right. And there are those who would say that the corporation is primarily a piece of private property as opposed to a social institution. But as I want to lay out, there really is a tension between the two concepts. So we're going to talk a little bit about what are the implications of corporations being property. What does that mean for how corporations are governed? What does that mean for how lawyers advise corporations if they are private property? And what room does that leave for social responsibility? And then on the other hand, if a corporation is not purely private property, but is in fact a type of social institution because it exists by virtue of the state's permission, how should the tension between maximizing shareholder value, shareholder wealth maximization, and corporate social responsibility be handled? And then the last question we'll try to answer is who will decide this? I mean, this could be decided in a number of different ways. This could be decided as a policy matter by, for example, Delaware. Although if Delaware changes the law, maybe corporations will move to another state. Maybe the federal government could preempt that and make a federal statute that goes one way or the other. Corporations are authorized to pursue corporate social responsibility without violating fiduciary duties. The federal government presumptively could come in and preempt that. Also, the shareholders could decide that. The shareholders could vote for corporations to include in their bylaws provisions that permit for social responsibility. Shareholders can make that decision. Directors could make that decision. Although, as we see in Ford, they may do so at their peril. But we need to at least get a better understanding of what this debate is, because there are some competing viewpoints on the topic. This is Professor Lynn Stout. And Professor Lynn Stout is, as you'll see later on, she features in our book pretty prominently. She's a heavy hitter in the world of corporate scholarship. And she has really helped us to understand this debate, which really began in 1932. Or maybe even older, but it certainly goes back to 1932, where the Harvard Law Review, oh, and by the way, this gets a little academic for a minute here, but bear with me. The Harvard Law Review published a debate between two preeminent scholars at the time, and on the one side was a man named Adolf Berle, a co-author of the Corporation and Private Property. Guess what side he was on? Who argued for what's called shareholder primacy. And the shareholder primacy view, this is important, by the way, something you should know. The shareholder primacy view that Adolf Berle advanced said that the corporation exists only to make money for shareholders. And, quote, all powers granted to a corporation or to the management of a corporation or to any group are at all times exercisable only for the ratable benefit of all the shareholders as their interest appears. The benefit of the shareholder, shareholder primacy theory. On the other side of the debate stood Professor Merrick Dodd of Harvard Law School. Dodd, D-O-D-D, you might remember Dodd-Frank, right? Also kind of somewhat anti-corporate statute, according to some, his namesake. Dodd disagreed vehemently with Berle and disagreed with the shareholder primacy thesis. He argued for, quote, a view of the business corporation as an economic institution which has a social purpose as well as a profit-making function. And Dodd claimed that the proper purpose of a corporation was not confined to making money. It also had an obligation to, for example, secure jobs and maintain good jobs for employees, provide better quality products for consumers, and contribute to the welfare of the community. And so if you'd like to get sort of the modern version, Professor Stout here has written an article in the California Law Review. Some of you may be looking for some sources. And 1932 is a bit dated. There's a lot that's happened since then. So in 2002, Professor Stout published an article called Lecture and Commentary on the Social Responsibility of Corporate Entities, Bad and Not So Bad Arguments for Shareholder Primacy. I'll post a link later, but for those who are jotting it down, it's 75 Southern California Law Review 1189 from 2002. I'll post that link later. But what you'll find is this is a very old debate. But one thing that's helpful is there have been a lot of revisitations of old themes through newer lenses. And in fact, Professor Stout has written her own theories about how to understand corporations. She calls it the team production model of corporations. And that was published in the late 90s and has been revisited. Most of these theories have been revisited. And there's really a huge debate and a ton of literature around this issue. Let's go a little bit deeper into the debate, though, and talk about a few other figures and what they had to say about it. So what are some of the arguments advanced in favor of corporations and private property? Well, some of them are going to be posited by a man who you may or may not recognize, a leading academic and a proponent of the modern version of this doctrine, who, it will probably not surprise you, is an economist. Does anyone recognize who this is? Famous economist. Milton Friedman. Milton Friedman from the Chicago School of Economics, a well-known libertarian, well-known Chicago School economist, right? So this is if you want to put this on a political spectrum, this is a person who would be on the right side of the political spectrum, for sure. But really a thinker who was lauded by his clarity of thought. He also won the 1976 Nobel Prize in Economics. Just as a footnote to him, this is really of the second generation of Chicago price theorists, the idea that the market sets a price, that you can learn what the price of something is if that product is sold in a competitive market with enough buyers and enough sellers. And he was an advisor to Ronald Reagan and actually Margaret Thatcher. So he crossed the pond. And he argued the following. He said, "When I hear businessmen speak eloquently about the social responsibilities of businesses and a free enterprise system, I am reminded of the wonderful line about the Frenchman who discovered at the age of 70 that he had been speaking prose all his life. The businessmen believe they are defending free enterprise when they claim that business is not merely concerned with profit, but also promoting social ends, that business has a social conscience and takes seriously its responsibilities for some of those things we mentioned, providing employment, eliminating discrimination, avoiding pollution, and whatever else may be the catchwords of the contemporary crop of reformers. In fact, they are, or would be, if they or anyone else took them seriously, preaching pure and unadulterated socialism. Businessmen who talk this way are the unwitting puppets of the intellectual forces that have been undermining the basis of a free society these past decades. The discussions of social responsibility of businesses are notable for their analytical looseness and lack of rigor. And by the way, if you come from the University of Chicago, the last thing you want to be told is that your argument lacks rigor. It's all about the rigor. What does it mean to say a business has responsibilities? Only people, Friedman argued, can have responsibilities. A corporation is an artificial person, and in this sense may have artificial responsibilities. But business as a whole cannot be said to have responsibilities, even in some vague sense. This doctrine of social responsibility, if taken seriously, would extend the scope of the political machine to every human activity. It is not different in philosophy from the most explicitly collectivist doctrine. It differs only by professing to believe that the collectivist ends can be attained without collectivist means. That is why, in my book, Capitalism and Freedom, I have called corporate social responsibility a fundamentally subversive doctrine in a free society, and have said that in such a society there is only one social responsibility of business: to use its resources and engage in activities designed to increase its profits, so long as it stays within the rules of the game, which is to say, engages in free and open competition without deception or fraud. Now, I usually don't quote at length, but those are not my words. He said them better. But that is one end of this debate. That is the libertarian side of this debate. The perspective that corporate social responsibility amounts to socialism, and that the only purpose of corporations is to produce profits. But of course, that is not the only view. As I mentioned, we have some competing voices, many competing voices, that actually champion the alternative, the premise that corporations are social institutions and need to serve a social purpose. And that is not just an option, but a requirement for their existence, as they exist by the permission and privilege of society. Professor Merrick Dodd, as mentioned before, probably made this case the most strongly when he made it originally in that Harvard Law Review paper in 1932. Professor Dodd said that the duty of managers is to employ the funds of the corporate institution, which they manage solely for the purposes, that the duty of the managers is to employ the funds of the corporate institution, which they manage solely for the purposes of their institution. Maybe I mistyped that. That purpose, both factually and legally, is maximum profit, has been commonly assumed. That maximum profit is factually the purpose of the stockholders in creating the association may be granted. Nevertheless, however, the association, once it becomes a going concern, once the corporation exists in the world, it takes its place in the business world with a certain ethical standard which appear to be developing in the direction of increased social responsibility. If we think of an institution which differs in the nature of things from the individuals who compose it, then we may readily conceive of it as a person, which, like other persons engaged in business, are affected not only by laws which regulate business, but the attitudes of the public, by public opinion as to the social obligations of businesses. If a business is tending to become a profession, then a corporate person engaged in business is a professional, even though its stockholders who take no active part in the conduct may not be. Those through whom it acts may therefore employ its funds in a manner appropriate to a person practicing a profession and imbued with a sense of social responsibility without thereby being guilty of breach of trust. And that was from For Whom Are Corporations Managing Trustees. It may not surprise you that the economist who came up with some Nobel Prize winning theories on price, right? This man strongly believes that by fierce and free competition, we will have lower prices and more freedom in society. And he's coming from that perspective from economics and from the mathematical rigor of Chicago School mathematics. On the other side, we have a law professor who may feel himself, as lawyers do, as part of a profession that has obligations. Our profession has obligations to give back. It's called pro bono. We all have an obligation to do that as part of our professional responsibility. And he's taking that into the business world and suggesting that that is something that institutions must have. Now, as I mentioned, both of these sides are certainly not without their critics, and you can certainly find various viewpoints, but it has real consequences. This is not just an academic debate between two old white men who wrote in 1932 and have since passed from this earth. Right? This is an ongoing, live, real debate that concerns everyone because it has to do with what boards are and are not allowed to do, whether directors, officers, other members of the corporate form are required or permitted or forbidden from using that corporation to advance social purposes. And all of us may be involved in corporations, and certainly all of us are affected by corporations. So the degree to which boards have discretion or permission or an obligation to engage in these sort of activities is fundamentally important. So does the board of directors have the discretion to determine whether a corporation should exclusively maximize shareholder value or to pursue a different agenda? What does the law say? Does the law provide directors with the opportunity to engage in any action other than maximizing shareholder value?
Yes.
Yes, right? Let's have an example, right? We have the Model Business Corporations Act. I actually pulled one from the Ohio Code. Many different states do authorize expressly, the law authorizes the directors to pursue a different agenda. The Ohio Corporation Code, for example, authorizes directors to consider the corporation's employees in making decisions. If you're an Ohio corporation, the board is authorized under that law to consider employees, to consider the needs of suppliers, creditors, customers, the economy of the state and the nation, the community and societal considerations, and the long-term and short-term interest of the corporation and shareholders. Now, Delaware does not have such a broad authorization, but Delaware corporations can take this onto themselves by adopting this into their bylaws. So one question you might ask, I don't have the answer, maybe something you want to research, how many corporations are doing this? How many corporations are how many shareholders are expressly saying we want our directors to be authorized to consider employees, suppliers, creditors, customers, the economy of the state and the nation when making business decisions? And a fundamental question is what happens to boards that change, what happens to corporations that adopt these provisions? Now, how do courts rule? The way the courts rule on how to understand whether boards are acting within the scope of their discretion or not is more complicated. And so I'll leave behind the academic and get to the technical and talk to you about a fundamental case that I hope will help to illustrate the amount of discretion that boards may or may not have. Before I move on, though, just as we're teeing it up, any thoughts or reactions to those sort of fairly polarizing opposite viewpoints about what a corporation should do? So let's talk about the Paramount case. I'm going to go ahead and do the facts of this case in part because they're really complicated. I actually, in addition to reading the case in the book several times, I went out and printed it and then read some background material. I found this to be a very complicated case. I don't know if everyone had the chance to read it, but this was a difficult case to deal with procedurally. So let me try to break down what happened in this case. This case is really about Time and Time Warner. Anyone here familiar with Time Warner? Joe, do you have a question?
Yeah, I'm sorry. Did you update the syllabus, or I might have missed the Paramount case?
It should have been included in the reading, but I will provide it for you. It was.
That may totally be my bad. I just going through chapter 4 of corporate social responsibility. I didn't see it.
Was it? It was not in the reading? Oh, I better give you the facts. 'Cause you're Oh, I'm pretty. Yeah, it was. Well, check and see if it's in your table of cases. I know it's in the book. Maybe in this edition they reduced that. You know what? I'm sure that's what happened. They probably reduced the case because the truth is it's really a complicated case. So I'm going to expand on that, and thank you for letting me know. I won't ask any direct. Yeah. Yeah, I always, as I mentioned, even when it was in a fuller version, it was always hard to digest. So I always read the full version of it. Well, at least let me then present the facts of it, and that way we can at least talk about it. Because I want to present the facts of this case, and I want you to come away with the concept of Revlon duties. Revlon duties is something that comes up, and I'm going to get to Revlon duties by showing how they apply in this case. So the only concept you need to know is sort of what constitutes a Revlon duty, which is an obligation on the board to maximize short-term shareholder value. And the point of reading this case and the point of discussing this case is to understand when boards have discretion to pursue different shareholder wealth maximization. Let me say that a different way. This case is about when boards are permitted to pursue long-term shareholder wealth maximization as opposed to short-term shareholder wealth maximization, and really gets to the issue of how hard it is to say what shareholder wealth maximization means. So this case is actually one that you probably will know better than you realize because you know all the cast of characters. This case is really about the Time Warner Corporation, which at that time was Time Magazine. Time Magazine is a journalistic magazine, and journalism is a profession. Well, at least it was. Now it's being kind of taken over by Huffington Post, but there really used to be people whose jobs were journalists, and there are codes of ethics and standards. And I being a little glib, it still is a profession, just one that has been eroded significantly by social media and the internet. But in 1989, journalism really saw itself as having this serious ethical responsibility to get to the facts and this concept of journalistic integrity. And this comes back to the idea of corporate social responsibility, the idea that corporations are professions and that they have this obligation to society. Journalism felt that way as well, and Time Magazine had that sense of itself. Time Magazine felt that it was the kind of company that had journalistic integrity, that it was out there to do good, to produce the truth, and in that way, that was its corporate social responsibility. Even if the story was unpopular, they would publish it, right? The focus was on publishing the truth, and they were successful in that regard. There was another company at the time that there was some interest in acquiring or merging with, and this was Warner. Warner Entertainment. Warner Entertainment had a lot of resources to produce movies and more modern forms of media. I think they also did comic books at the time, and were able to have access to a broader group of people. And Time Magazine was not sure about the road ahead, and they began entering into negotiations and conversations with Warner about a merger. So we've talked a little bit about mergers. Mergers are when two companies decide to become one, and typically one company buys the other. In fact, in all the cases, there's some kind of one company transfers to the other shareholder something, whether it's cash or stock. But here, the companies were trying to put this as if it were a merger of equals. And this is a lot of backstory perhaps, but this was in part because the CEO of Warner really thought he was a big deal and didn't want to step down from that role, so there's going to be co-CEOs for 5 years and all this. It was all these big personalities. So they're going through these merger negotiations, and the problem with these merger negotiations is that they're focused on preserving the Time culture. Time is a journalistic, professional company, and they think that they have a role to play in the world. And their value, in fact, their whole concept is maintaining this journalistic integrity. And they need to have some control so that they publish the truth and not the popular stories. They don't want to become the Huffington Post. They want to remain Time Magazine. And so they need to maintain that culture. So this is all going on, and Paramount comes along, another entertainment company, and says Time would be a great acquisition. And they want to buy Time Magazine. Now, Time doesn't want to sell, doesn't want to merge with Paramount, because Paramount, they felt, did not share their values. But Paramount was offering something that could surpass values. Value, with no S. They were offering to buy the shares at a huge premium. And so what they were trying to engage in, Paramount was trying to essentially disrupt the deal while the merger negotiations were going on. Warner and Time want to merge, become one company. One company would be too expensive to buy. And Paramount is trying to shoe in on that deal and buy the company before it merges, buy Time Magazine. They felt the value in Time Magazine, and they were going to take it, and they were going to gut it, and they were sell it off, and they're going to scrap the journalistic integrity, and they're going to pump out Time Magazine, and they're going to make cash money. And because they could turn this silly, professional, responsible corporation into a much more profit-making machine, they valued that stock at above its market value. They could do something with that stock once they controlled it. So after years and years of negotiations go on, and Paramount, and at what they call the 11th hour, the merger between Time, which obviously happened, you're all familiar with, like Time Warner now, right? I mean, now it's Time Warner. There's still Time Magazine, but Time Warner Cable Company and Time Warner is a household name. Obviously, the Paramount deal didn't happen. Their logo still looks like this. It's not Time Paramount. So what happened here? Well, as the merger was getting close to closing, Paramount offered the shareholders directly to buy their shares, the shareholders of Time. So the board, this is what's called a hostile takeover, because the board doesn't want it to happen. The board wants to have a merger with Warner. Why? Because then the board maintains its creative control. They maintain their socially responsible journalistic ethic. They maintain their identity and what they claim their long-term value. And Paramount says to the shareholders, sell your shares to me instead. You'll get a premium over the market price. Now, that didn't happen. Why didn't it happen? It didn't happen because at that time, Time Company adopted something called defensive procedures, defensive provisions. Some of you are, I know, working on this for your papers, but you might have heard the term a poison pill. There are lots of ways that a company can prevent itself from being acquired. There are ways to preclude a merger from occurring, and certainly to preclude a hostile merger from going forward. Okay? So the question in this case, and so then Paramount, the reason that, by the way, the case is not Time Warner in the caption, but Paramount versus Time, Paramount was not only a hostile takeover party, they weren't just trying to buy the shares, they also were a shareholder. Paramount is a shareholder of Time, and Paramount said, Time, board, you have to maximize shareholder value. And there's an offer on the table for a 50% premium over the shares. You need to take that offer because you have a duty to maximize short-term shareholder wealth, my wealth. You have to do it by taking my deal. Right? So they kind of had a subversive reason for it. So the question was, so they asked for an injunction. They go to the board. Well, first they go to the board. The board says no, leave, and so they go to the courts, the Court of Chancellery. And they offer to, they ask the court to enjoin, to stop the Time Warner merger from going forward. So the question was, is this case going to be enjoined? Is this injunction going to be granted? Or, to put it another way, does Time have an obligation to maximize short-term shareholder value? Or are they permitted to consider corporate culture, their employees, journalistic integrity, social responsibility, and with it long-term value? Are they permitted to do that? Well, it turns out that it comes down to two concepts, whether or not the board had Revlon duties and whether the board had Unicall duties. Revlon duties turn out to be more important, and so I'm using this as a vehicle to also explain to you what Revlon duties are. We'll come back to them if we get to mergers at the end of next semester, but they're an important feature of mergers. So I want to talk to you briefly about these Revlon duties, and we'll see if they existed. So as we have seen and as we'll learn, the business judgment rule generally protects directors when they're making a business decision, and certainly the decision to sell a company or not, that's a business decision. Are you going to sell the entire company? Are you going to liquidate it? Are you going to go to this buyer or this buyer? That's a business decision. But under what's become known as the Revlon Doctrine, the business judgment rule does not attach when the corporate decision makers are making a decision about a transaction where control would pass to a third party. Now, why might this be? This is fundamentally about directors having a conflict of interest, is how I read Revlon duties. If you're concerned about losing your job because a merger will proceed, are you going to be able to make an independent choice? Are you going to be able to make a business judgment where you're concerned for your own job and your own salary? Yeah, Joe.
Can you say that one more time? The
The business judgment rule does not attach when directors are making corporate decisions about a transaction in which control of the company would pass from them to a third party. If the directors might lose control of the company under certain conditions, and therefore, by the way, if there's new shareholder, what did Paramount want? They wanted to turn this journalistic company with integrity into a money-making machine. And so they're probably going to get rid of all the journalists on the board of directors and everyone else who thought that pursuing this path, they want to maximize short-term shareholder wealth. They want to carve the company up into 6 different silos and have them sell magazines. Right? They're going to sell People magazine, not Time magazine, I guess. So this Revlon Doctrine comes about because when companies are in a position where they might lose control, the board, there's a presumption that the directors are not able to act independently. And the Revlon duties are, and I'm going to get a little more specific here, triggered in 2 particular cases. The first time that Revlon duties are clearly triggered is when a corporation initiates a bidding process, puts itself up on the auction block, and actually solicits bids to sell itself or to otherwise reorganize and break up. That wasn't the case here. This company was not going out and soliciting active bids. It wasn't putting itself on the open market. There wasn't a bunch of different bids to consider. They only had one conversation, and then another company came in and tried to buy them out from under them. So it was the first prong was not targeted. The second question is when a company is the target of a hostile takeover, and it abandons its long-term strategy to break up the company and avoid the takeover, right? It abandons its long-term strategy to avoid the takeover. So the question in going back to Paramount was whether or not the directors were going to have the business judgment rule, in this case, where there was a proposal of a change of control because there was this solicitation by Paramount. And again, mostly what I wanted you to do is to see the 2 aspects of the Revlon duties and to understand that this is going to tie into our conversation about conflict of interest. That the Revlon cases, the whole line of cases, which are prolific, come to the point that directors are not able to make a business decision, an independent business decision, when they might lose their jobs. And so these change of control transactions often create a duty on the board of directors to maximize short-term value, because at least the courts can recognize that. You sold it for $150 or you sold it for $175. $175 is more. That's what you have to do, board, because we don't trust you right now to make a decision in the best interest of the shareholders. So the first issue then is whether the Time Warner agreement itself triggered these Revlon duties. And the answer is no. Because in this particular case, the Time Warner agreement was structured in a way that Time would remain, that Time would continue as an entity. And so it was narrow, it was a close case, but Time is still a corporation today. Time hasn't disappeared, right? Time is now Time Warner. And it has persisted. It did not actually sell itself. Although this was one of the famous cases where there was a quote-unquote merger of equals, it was found that Time still predominated. And so the first prong did not attach. And so here we had a merger of equals, and as a result of this being a merger of equals and not a sale of the company, there wasn't this obligation to maximize short-term value. But note that it was very close, and that boards of corporations can have obligations to maximize short-term value, especially where they're conflicted about the long-term interests of the company. So the Revlon duties did not attach. The second and more minor point has to do with something called Unicall duties. So this is a company, you've probably seen 76 gas stations. I looked up Unicall. I actually didn't know that they were this is the former name of 76 gas stations, which later had a merger with Chevron. And I believe it was the process of that merger that gave rise to this series of cases. And this doctrine pertains to when a board adopts these anti-takeover devices. So an anti-takeover device, like I mentioned, is when the board changes something about the corporate structure to avoid a hostile takeover. I don't have the time and the space, and the truth is it's hard to understand some of the mechanics. Essentially, a poison pill defense, though, essentially is a mechanism by which if someone tries to buy the shares from the shareholders individually, the company makes more shares, and it dilutes them, and it keeps diluting them. So as more shares are purchased by the shareholders, more shares exist, and it effectively becomes incredibly expensive or impossible to purchase the company on a hostile takeover. The details of a hostile takeover aren't as important as the idea that the board can cause the company to ward off a hostile attack. The question is, are they permitted to? Are they permitted to do that? The Unicall Doctrine says that when boards adopt defense measures, that protect against hostile takeovers, and there are many. The famous one is the poison pill defense. Right? I think Marty Lipton came up with it in the mid-'80s. But again, that's another interesting area. You can look up different takeover defenses and where they came from.
I'm sorry. Isn't that what they were? Isn't that the term of art used in the whole Papa John's thing?
I don't know if Papa John's adopted a poison pill. I'm not aware of a hostile takeover with Papa John's,
No, that's what I'm saying. Is when Papa John, when he made all those comments, the board had decided on some type of poison pill.
Oh, it's
for
so
it.
that's
Is it art in that context as well?
well so Papa John, I forget his real name. John what's his? Do you know his actual name? I'll just call him Papa John. Mr. Papa John. Shatner, like William Shatner, but spelled a little differently. Papa Shatner, John Shatner, owns like 30% of that company. And so if he were to purchase another 20%, he would have voting control. And so it's kind of ringing a dim bell there, but I would not be surprised if the board responded by adopting some kind of defense to prevent him from obtaining control by going out on the market and making a tender offer, which would raise certain issues and would raise exactly this issue of Unicall duties. Anytime the board adopts defensive measures to protect against that, and it sounds like they did in Papa John's. You have your laptops, you can Google Papa John's poison pill Shatner, and something will come up if that happened, right? So how does this doctrine work? The Unicall duties apply when the board adopts a poison pill defense, and then the board has the obligation to show, first, that they had a reasonable grounds for believing a danger to the corporation existed, a danger to corporate policy, and that the defensive measure is in reasonable relation to that danger. So how did this play out in the case here? Did this duty attach? Well, yes, this duty did attach, because here the board clearly adopted defensive maneuvers, right? They were adopting poison pill defenses to preclude a takeover. But in this particular case, and that means the business judgment rule, again, doesn't attach, the full-blown court review of the board decision. And that's trouble for a board, right? But in this case, the board came out on top. The Unicall duties did attach, but here it said that the defensive measure was appropriate, that the paramount offer was not a legitimate offer that was going to enhance shareholder value, but it was really a torpedo thrown at the ship at the 11th hour when the merger was determined to be good for the company. The court basically said, in this case, that Time Warner, as it now stands, or Time, had the right to consider things like social responsibility and journalistic integrity as part of the long-term mission and value of the corporation. The court said that unless there's a specific reason, like Revlon duties, to maximize short-term value, the board is authorized to consider long-term value, and, for that matter, is authorized to achieve that long-term value through commitment to responsible things like journalistic integrity. And so, although the duties attached, they were succeeded here. Because by preventing the paramount bid, the board was not trying to keep its jobs, not at least not first and foremost. They were trying to prevent what amounted to a competitor who wanted to get a short-term value by chopping up the company, and they were able to make the case that they were going to promote long-term shareholder value by sticking to their values. And so this case overall really stands for the idea that nowadays, under modern thinking, boards do have some real freedom to pursue long-term value, and sometimes that long-term value can come through being socially responsible, or committing to professional principles at least. Mhm.
And I was doing my 401k, and if you have a company that decides that it wants to operate or ethically to be considered ethical enough to qualify as that, whatever, wouldn't that conflict with Revlon duties? Because if you were spending more to operate more ethically, then you're really not maximizing profit.
So, in order for Revlon duties to kick in, there has to be some type of sale of the company being proposed. But let's take that example. Let's say a company decides. Now, first off, on your point, I just want to make this point. There are funds called SRIs, Socially Responsible Investing Funds, and I think it was BlackRock. There are a couple major private equity groups that own like huge chunks of corporate America, like huge percentages of corporations out there. And this came up with Dick's Sporting Goods. So Dick's decided to stop selling assault weapons after yet another school shooting. And a private equity firm, I think it was BlackRock Capital, said, we're only going to invest in companies like Dick's that are standing up for this sort of social responsibility. Now, let's play that forward. Let's say that someone got upset. Maybe a shareholder at Dick's was upset because this would potentially decrease the stock value. Because sure, BlackRock's investing in us, but maybe gun sales are really profitable, and we should be selling guns. It's a sporting goods store. We want to cater to hunters, and there's some kind of reason. And a company comes in and offers to buy Dick's. Or for that matter, Dick says, we're a mess now, we're going to sell the company. In that case, the Revlon duties would attach. But there has to be some type of sale for the Revlon duties to attach. And the Unicall duties attach a little more frequently because they have to do with preventing a hostile takeover by adopting defenses. Yes?
Can you go over those three elements of the Unicall duties? There has to be reasonable grounds to believe there's a danger.
Yeah, it's really just two. It's really just two. And so the basic concept of Unicall duties is that the business judgment rule does not apply when it does not apply to a board's decision to adopt takeover defenses. Call them anti-takeover defenses. A poison pill is an example of an anti-takeover defense. The business judgment rule does not apply to that decision unless the board can show, one, that the board had reasonable grounds for believing a danger to corporate policy exists. The board needs to show there are reasonable grounds for believing a danger to corporate policy exists. And two, the defensive maneuver is reasonably related to that danger, that specific danger. This is to prevent the boards from adopting defensive procedures just to keep their jobs. You could see how a board might want to do that. A shareholder says the board's doing a terrible job. The board of Dick's did a terrible job. They allowed the CEO to stop selling assault weapons. I'm a 20% shareholder and I'm really ticked off. And I'm going to offer a $30 premium on the now depressed share price of shares. We're 150, now they're 120. I'll offer 175 to every shareholder who's willing to tender their shares to me so long as I get to 51%. And then I'm going to get rid of those directors and put in some guys who love guns. I got to adopt some NRA directors, and I'm going to change the corporate policy. The board could respond by adopting a poison pill, making it very expensive to buy up that amount of stock by putting more stock into circulation. And if they were to do so, the board would have to show that these two elements exist, that there was a reasonable ground for believing there was a danger to corporate policy and that the defensive measure was in relation to that danger and not just to keep their board jobs. And these both really fit in with the concept that we'll learn next semester when we talk about the duty of loyalty and conflicts of interest, because you can see how a board member would be conflicted inherently about keeping their job. So we understand now that directors seem to be authorized to pursue, we've always known directors are authorized to pursue short-term shareholder wealth maximization. And the Paramount case seemed to suggest that, absolutely said, that they can also pursue long-term wealth maximization and seemed to imply that they could maximize that wealth through, in this case, we'll call it professional ethics, which may be social responsibility, maybe something else, but certainly has the flavor of corporate social responsibility. And board authority in cases like in Ohio and in other state statutes, although not necessarily in Delaware, or in cases where the company has adopted bylaw amendments that specify the board has these rights, the authority is very broad. But it's not unlimited. And I think it's important that we understand why it's not unlimited. And we need to look at what boards cannot do, what directors cannot do without violating their fiduciary duties. And the classic case for this concept is the case of Dodge versus Ford. I hope this was in the reading. Yes, okay. Because this was the big case for the day. We have time to go through it. So, anyone here heard of Ford Motor Company? Sure, it's a blue chip stock, it's one of America's largest corporations. It's also kind of an incredible story, and it was conceived of by a really an incredible person. I mean, did incredible things on many sides, good and bad. Henry Ford was an interesting person, by the way. I mean, he was definitely a mechanical genius from an early age. There are stories that when he was 9 years old, he took apart his father's pocket watch and meticulously put all those little gears and springs all back together. And he was fascinated with machines, but he lived in a rural area outside of Chicago. I think it was like 14 miles to Chicago. It's a long walk, right? 14 miles. It's flat there, unlike here, so it's not quite as bad as walking 14 miles across Pittsburgh. But really gave him some separation, and he had this desire and this drive, and so his family wanted to support him and his interest, and so they got him into the city. I think he stayed with an aunt and went into the city and began working with machines. And he was able to attract investors because he was also a really magnetic personality. And in a paper I wrote recently, I compare him in that regard, at least, to Elon Musk, a person who was, they recently said that there's a Musk bump to the Tesla stock. If they got rid of Elon Musk, the price would go down because his charisma carries the company. Ford seems to have been the same way. He organized the Ford Motor Company in 1903 with an initial capital of only $150,000, although that's in 1903 dollars. But it's actually, I had the math, it's a couple $1 million today. Like a venture capital, like a startup. He was not an electric car startup, but a gasoline car startup. And by the time of this case, he had grown, and this case was 19. By 1919, he had grown the capital from 150 million to 2 million. And so this company was pretty profitable. It was making money. And what was it doing with this money? Well, it was giving the money back to its investors. This is called a dividend. The concept of a dividend is quite simply when you take corporate profits and you give it to shareholders. You can also call it you dividend it out. And you get usually a percentage. There are different kinds of dividends. You would have covered those if you had watched the lecture on capital structure. There are special dividends and there are regular dividends. And if you take my venture capital class, you'll learn that it's more complicated. There are cumulative dividends and non-cumulative dividends. Dividends are when companies take their profits and give them to the shareholders. And since Ford had a lot of profits, it had been giving dividends every year in 1911 to 1915. And the shareholders are happy, right? You'd be happy too if you were getting money back, and there aren't that many companies that offer dividends these days. So, but in 1916, Henry Ford, CEO and a major shareholder, declared it to be the policy of the company to stop paying any special dividends and instead to put the money back into the business. Now, that on itself is not a problem to say, we can't afford to keep paying the shareholders. We need that to improve the business. But the problem was what he said about it. He said, we're going to put it back into the company for the good of the workers. For the good of the workers. And later, he even implied that for the good of the consumers. And on its face, this new plan clearly did not seem to be in favor of the shareholders. In fact, I think Ford's first mistake, one of his many mistakes in this whole corporate governance project, was to say, my shareholders are too wealthy. I don't want them to have any more money. I want the people to have that money. Now, this is going a bit too far, as you might imagine. I mean, this is definitely not only not thinking about shareholder wealth maximization, this is like shareholder wealth minimization. I want to take the money from my shareholders and give it to somebody else. And I don't have any corporate purpose for doing it. Well, this is what brought up the lawsuit. because Ford was taking into account the business's effect on others to the point of depriving the shareholders of profits they thought they were entitled to have. Now, some of its shareholders were the Dodge brothers. If you heard of Dodge, Dodge Ram over there, right? Number one competitor, F-150, Dodge Ram 1500. These are two of the best-selling vehicles in America, right? Major competitors to this day. And the Dodge brothers were actually using their dividend income to fund their competing company. Now, this isn't in the case, but I think this is part of the backstory. Ford was trying to preclude competition by his own shareholders. That at least seems to be part of the story. Why did he not want them to have that money? Well, because they were going to compete with him about it. They also had different philosophies about cars, by the way. You may be familiar with the Model T. Cute little thing, right? It was cheap. It was cheap at the time. Not so cheap now, obviously. They're pretty classic. But this is not what the Dodge Brothers cars look like. The Dodge Brothers vehicle was twice as expensive. It was appointed with leather. It was ornamented. It was not for the common person. It was twice the price. And they were trying to push Ford further into the luxury market. So there was a fundamental disagreement. Now, who controls the company? The shareholders or the directors? The directors and the executives. So the shareholders can't really push in this way, but they can push in the sense of demanding their dividend. So, back to the Dodge brothers. They had begun to manufacture cars in competition, and they owned 22% of the company's stock. So, they sued the Ford Motor Company for two things. First, to compel the payment of a dividend. Pay us the profits that you're making. And two, Ford wanted to build a new plant called the River Rouge plant. He did build it in the end. And this new plant was supposed to be more vertically integrated. It could not only process steel, it could smelt ore, it could do a number of other things. It was huge. It was going to produce more cars at a faster rate and, in the process, reduce the cost per car. It's economics of scale, right? This had positive economics of scale. The more cars you produce, the less it can cost. The concept was the new plant was going to lower the cost of the car. And Ford wanted to lower the price of the car anyway because he wanted more people to have this vehicle. At least that's what he said. Ford said a lot of things, as we'll see. And that may be, it may really be more about the message than the action in this case. So Ford wanted to expand and create this vertically integrated production, one that could mine its own ore and build its own ships to transport the ore and building smelters to make steel. And in the process, or in a prelude to it, he wanted to reduce the price of the cars from $440 that year to $360. That's a huge price drop. And it didn't seem to make sense because this car was selling out. They were selling all of their units at full price. So it's really hard to understand economically why he would want to do that. I have an explanation, but I'd like to hear from you. Any thoughts on why a person, a corporation, might actually, in this tumultuous time, sell their cars at less than they could get for them?
To saturate the market. So
Yeah, go saturate the market and drive the competitor out of business. Yeah, so this, at the time, there was no statute on the books, but now there's a statute, I believe it's the Robinson-Patman Act, could be mistaken, that talks about predatory pricing. Pricing so low, using monopoly power, or market power, really, because you're not a monopoly yet, using your market power to price an item so low that you drive competition out of the marketplace and then spike the prices back up and collect those monopoly rents. So there's at least one business explanation. It's not legal today, Sherman Act, Clayton Act, etc., but it's at least one business reason. That's not what he said. He said he's for the people. Joe.
3 questions. 1, Dodge sued to compel Ford to pay special dividends?
Yes.
They already paid the regular.
They paid the regular dividends. They wanted the special dividend on top.
Okay. I already forgot my 3rd question, but the second one was, isn't that exactly what Rockefeller did? He lowered prices so much so that it forced everyone out of business, and then he chopped them up, and that's what brought out, it kind of forced.
So I'm not a huge history buff, but I know a little bit about the area of competition. So I believe what was going on. So and someone here can help me with these dates. I believe the Sherman Antitrust Act was 1890 and the Clayton Act was 1914, and both were responses by the federal government to perceived anti-competitive practices in the railroad and the oil industries. Right? And again, feel free to jump in. And among those were what we called the oil barons and the railroad barons, which included the Rockefellers, the Carnegies, and others that were almost certainly engaging in these, and they were engaging in practices that were outlawed by these statutes. Now, the statutes had some very early versions of economic thinking, and I'm not sure how well they were all thought out, but yes, I think they were engaging in that sort of thing.
I remember the third one. You said what was that act? Robinson-Patman?
Robinson-Patman?
Robinson-Patman.
For predatory pricing, yeah. And that was later. I think that was in the 40s, but I'm much hazier on that one. Yes, sir.
My understanding was it wasn't just Rockefeller, but everyone adopted that model. So there were like the sugar trust and the wheat trust.
Yeah.
So everyone.
Yeah.
It's all monopoly.
Yeah, there was a lot of monopolies. Well, it was what you would call an oligopoly, but a durable oligopoly because there was kind of outward collusion. There was the Sherman Act has two provisions. Section 1 deals with collusion, and Section 2 deals with monopolization. I think in the case of predatory pricing and Ford here, we would be looking at monopolization, and collusion is like those trusts. Yeah, I think that's right. Yeah. The history of competition law is really interesting. I think we got it wrong for a long time. But in any event, there were some business reasons, but Ford didn't say that. Ford didn't come out and say, my purpose is to make this company super profitable by undercutting competition, driving them out of business, squeezing my shareholders because they're also my competitors. Ford said he wanted to put people to work. Ford said he wanted more Americans to have cars. Ford said he wanted more people like him who were growing up 14 miles from Chicago to be able to get to the city and back every day. And his vision of the corporation, his vision of corporate social responsibility was complex and challenging. And I think challenges some of our fundamental issues with CSR. His vision was that corporations owed a responsibility to society. He was a strange blend of capitalist and socialist. And he believed that industry would spur trade and create what he would call an industrial peace. He thought the solution to peace was through industry and through a global sense of CSR. At least that's what he said. What he didn't say, but what he should have said, is that he wanted to make money. He wanted to build this plant because he would be able to produce cars cheaper and sell them for more. If he had said that, I don't think there would have been a problem. So he wanted to reinvest the money into this River Rouge plant through this reinvestment. Oh, and by the way, just as a side note, it's unusual to do things this way. The way that you'd usually build a plant like this is like taking on debt or something like that. It's unusual that the company had this much cash. But it's a company like Apple. Apple has so much cash. Like, it's ridiculous. They have more cash than probably the least wealthy 30 nations in the world combined. I'm making that number up, but I'm probably not far off. I mean, they're a $1 trillion company. So this is kind of unusual. So why would he want to do that? We talked about why reducing the price of the Model Ford. This is my joke about reducing the price. They cut the top off. Okay, yeah. Right, so they're chopping the price, and you know, what is his message here? He could have had a message about beating the competition. He could have had a message about saturating the market. Instead, he had the message of getting the cars into the hands of more people because they deserved it. Is this contrary to proximate maximization? Yeah, at least in message. It may not have been in meaning, but the court seemed to take him at his word, and maybe because this guy was a really big figure. Maybe the court took this case more seriously because he was a really contentious figure, a really difficult figure. As I said, he claimed to be a socialist. And we have this newspaper headline, Ford gives $10 million of profits to his employees. This hits at the foundation of what capitalism means. What's going on in 1914? The Bolshevik Revolution is happening in Russia. We've got turmoil in Germany. We have anarchist movements across the country, across the world. We have socialism, and all these things are frightening the American people and challenging some of the views that people had. And in all this, he is saying he's doubling the pay and giving his profits to his employees. And he became very popular. He was a very popular person. He did things like institute what he called the $5 workday. The $5 workday was the notion that everyone who worked for Ford could earn $5 a day. Well, if you were white. It turned out that the $5 workday didn't apply to everybody. And there was something more troubling at work here. So a couple other facts to realize in the background that may have motivated this case was that Ford was on the side with the Nazis. He believed in some of their theories about race, including anti-Semitism, including really being anti-African American, and he forced his employees to submit to cultural training. So he did hire whites from Ireland. Maybe some of you have family from Ireland. Well, you better not speak Irish when you're, have an Irish accent even, when you're at Ford's plant. You couldn't have traditional Irish dress. And he also instituted a policy that in order to get the $5 workday, you would not only have to take courses and speak English, but essentially disavow your heritage, assimilate into America, and give up drinking, gambling, and premarital relations. He had what amounted to a Gestapo that went to people's homes in the night to see if his $5 a day employees were gambling or drinking or had women over who were not their wives. And by the way, I didn't see a $5 workday for men in any of my research either. So his idea of corporate social responsibility is mixed. Yes, he promoted a $5 workday, but not for blacks. Yes, he promoted a $5 workday, but only if you give up your heritage. He was promoting his own vision of what was appropriate for society. And one of those visions really did cross over into the sales realm. So this is a sign on the street from the 1920s. I think this was 1920 itself, and maybe a little, no, it must have been later than that. It must be getting into the 30s at this point, right? So Ford was well known as being affiliated with Adolf Hitler for a couple of reasons. Adolf Hitler featured Henry Ford in Mein Kampf. He's the only American industrialist in that book. And in that book, Ford is, quote unquote, revered by Adolf Hitler for his work. And Ford was doing something with his funding which should trouble us from a CSR perspective. Now, let's assume that he had this view and he held it, and he really believed in this view for a minute. But he had done something which I think should resound today in terms of using his corporate funds and using his corporate arm to make political speech, even maybe at the expense of wealth maximization. He bought, for the price of $5 million at the time, that's $65 million today, a newspaper called the Dearborn Independent. Dearborn's a suburb just north of Chicago. And he ran this article, The International Jew, the World's Problem. And he put this magazine in his car dealerships. He required that Ford dealerships, which are independently owned and operated, had to carry this magazine. Did that have an impact on sales? Was that reasonably calculated to lead to shareholder wealth maximization? Was he entitled to do this? Right? This raises, I think, some really fundamental questions about what happens if we allow CSR. This to me is the downside of it. This man really believed, if I read his biographies, he really believed that if we could only get rid of Jews, the world would be a better place. So he was engaging in corporate social responsibility when he put that newspaper. He was engaging in his mind in CSR when he said the protocols of the elders of Zion and the blood libel was true. Now, even more troubling, though, than all of this, because a man's entitled to say what he wants, but using the corporate form to do it, that's the area that's complex. That's the area that it becomes a bigger issue. And I want you to think about this in the following way. What if people liked this? What if people bought Fords because he was doing this? What if he was maximizing profits? What if the way to maximize profits in America in 1930 was to publish this magazine and put it in your dealerships? How do we feel about that? Do we feel that there's any obligation to do that? Is there an obligation not to do that? I don't have the answers to this, but I have some questions. And I think that we need to better understand if we're going to permit use of the corporate form to make political speech, to make social speech, people are entitled to their different views. And I have my feelings about this view. I'll give you a hint, it's not positive. But at the same time, I'm an advocate of free speech. But I'm not an advocate of using other people's money to make this type of speech if there's an obligation to do otherwise. Yeah, question.
So, did people go for this? Like, I have to get a flu shot at work, which I got a flu shot every year, but now that they want me to get one, I won't get a flu
flu shot. And if I was making whatever kind of money, but couldn't drink, sleep around, gamble, or do it, like, people really went for this?
Absolutely. I mean, at that time, wages were pretty depressed. These factory jobs were seen as pretty peachy, and people wanted to be part of that. And some people bought into it. I mean, he sold 500,000 of these. Someone's buying this, right? Someone's buying this, and someone's buying into and he's getting press like this, and he's getting press like this. Reasonable minds can disagree, and people viewed this differently. People viewed his actions differently. So the bigger question, I think, is not do we agree, do we disagree, but what happens when we allow CSR to this level? And we might think it's great, because when we see a company doing something we believe in, we champion it, and we get frustrated when the shareholders sue. I put this case up just to present we're not always going to agree with those actions. And to what extent do we want the moneyed interests, as they're so called, to be making this kind of speech? And to what extent do we want to obligate them? If this is the kind of publication that increases shareholder value, should it then be permitted? Should it be required? And I think that these are important issues for us to grapple with. But let's return to the case so I can keep moving the class forward. Was he compelled to pay the dividend? Yes. In this case, he was compelled to pay the dividend. It was a really unusual case. As you can see, I hope I paid. These are really outlandish facts to an extent, right? I mean, you don't get facts like this in just every case. This is a very, very unique character and person. And it was a very odd holding. A divided court ruled that since a business organization is carried on primarily for the purpose of profiting the stockholders, the powers of directors are to be employed for that end. The discretion of directors is to be exercised in the choice of means to attain the end and does not attach a change to the end itself. They cannot reduce profits and, going a little farther, cannot have a non-distribution of profits in order to devote them to other purposes. So it seemed like because Ford wanted to use these funds for other purposes, he had to give them to his shareholders. Now again, that's a really unusual case. You're not going to find a modern case where there was compelling a dividend. But that's how extreme these facts were. That the court seemed like it felt, the Delaware court, the capitalist court, wanted to take the money out of Ford's control because of how extreme these facts were. But even so, he was not compelled to abandon the River Rouge plant. He was allowed to continue reinvesting that money into a business operation. This is a business decision. He wanted to build cars. He wanted to build more cars and build them cheaper. That's what Ford does. And so as a result, they was not enjoined with regard to the vertical integration plan. So, in disposing in the issues of this case, I think it's important to understand the color and the context going on. Right? We have, in this case, a lot of social unrest and a lot of discussion about the purpose and meaning of corporations. I see in this case the Delaware court doubling down on the notion of shareholder wealth maximization, in part as a way to promote capitalism. And I hope you heard when I talked about what Milton Friedman, when I gave you Milton Friedman's words, his concerns, that was not a lot later, that was 1932, the concern that corporate social responsibility would lead to socialism. He probably had Ford in mind. So before we run off to say CSR is the solution to everything and we want full authorization, I just want us to have this sense of caution a little bit, because at the end of the day, it's one person controlling a lot of other people's money. And if it was your money, I shouldn't speak for you. If it was my money, I wouldn't want it to be going toward publishing The International Jew and putting that in showrooms, even if that improves shareholder value. So I think this case raises some really fundamental questions about what are the limits of CSR. And you can look at it and you get the letter of the law, which is to say courts, businesses have to maximize profits. But I think we have to look to more modern cases to really understand it, because it was such an unusual case. Questions, comments about Ford? Sir?
So, I did a quick background on this, and as you said, and to build off of what you said, he was the only American mentioned favorably in Mein Kampf. Himmler reached out to him and commended him, and they even said that they wanted to model Volkswagen after Ford. Obviously, for his racist and hate-filled views. Do you think that if let's say today, someone like Elon Musk said, you know what, I don't want to hand out special dividends. Someone who, whether you agree with him smoking weed or any of the other things he's done, as far as we know, isn't a super racist like Henry Ford. Do you think that the courts would rule in the same manner, or do you think they would say, you know what, maybe he really is looking out for his employees, which in turn, like long term, would create better wealth for the company?
I think the court would have come down on, I think we've actually gotten to be even more critical. I mean, let's take the marijuana example. Let's say that Elon Musk was using his position to propose federal decriminalization or legalization of marijuana. I think there's some grounds under which a court could say, you as the director of Tesla can't do that if it disturbs shareholder value.
I guess maybe I should clarify. Ford clearly had ulterior motives to the things that he did behind the...
But Musk might too. I mean, he might really think that we got to get to Mars in 50 years because the planet won't exist. I mean, he's said things to that effect, right? He wants to create a society on Mars. And he's got SpaceX to do it, and he's launching Tesla cars into space to make a point about SpaceX. Now, again, this is a lot less politicized than anti-Semitism or putting blacks in the most dangerous part of the factory and paying them 20 cents on the dollar when you're claiming to be a socialist, right? This is less political than that. But, saying we have to go to Mars and I'm going to commit the company's resources to making a civilization on Mars is maybe a violation of his fiduciary duty. It's also complicated because it's, as you can see, again, maybe it's easier to deal with the Musk example because it's less, right? I mean, it's less right there. But that's part of his magnetism. That's part of his charm. That's part of his charisma and his fundraising. But it's also part of why people say he's off his head, and why I think there will be lawsuits again. The SEC is already investigating him. 2 different counts. So.
I guess it's clear that Ford was overtly, like he put his views out there in a very extreme manner. So I guess my question was,
if it was more subtle, would it be a yeah?
Said, instead of special dividend, I'm going to give every single employee a $1,000 bonus to make all of our employees happier, to promote additional production.
Hey, once he says that one of the purposes of giving them that bonus is to enhance production and get out of production hell, he's good. That's a business purpose. That should probably fly. Okay. But if he says, I'm going to put more of the company's resources into getting us to Mars because the human race won't survive another 100 years here, see Stephen Hawking, right? I mean, if his shareholders, if that's not founded in paper and process, if that's just in his head, then he hasn't necessarily met the business judgment rule standard, and he doesn't necessarily get protected in that decision.
I guess my initial confusion was just that when you go through what the book has on the case, you don't get that kind of background. You don't learn that extreme racist and anti-Semitic history that was
and socialist,
around,
yeah,
socialist history that was around in the time. So at first glance, you're looking. He says, "I want to give back to my employees." And that sounds like a great thing, and then you actually.
So now I think I see your point better. Would a company look? Would a court today look more favorably? Well, I think as we'll see as we turn to the section on sort of ability to give charity, which might be a little clearer. Like Elon Musk could say Tesla is going to build homes or provide electricity. And I think he did something like this. Didn't he say he was going to provide batteries for Puerto Rico?
Yeah.
Right? I mean, he didn't say he was going to make money providing batteries to Puerto Rico. He said Tesla has a obligation to help in Puerto Rico. Maybe that's the counterexample. And would a court get on him for that? No, I don't think so. I think a lot of what happened in Ford could only be understood. That's why I spend the time going through it. I mean, I think it is interesting, but I think you really misunderstand Ford unless you understand the historical context. And there's a tendency to over-apply it into a much broader context, whereas I think a lot of it had to do with that person at that time. It was a really remarkable time and a really remarkable person.
I guess, you have that point. That history, that's...
But if Elon Musk wants to put a bunch of batteries in Puerto Rico after a hurricane, I don't think a court's got to sue him for that, but I don't think a court's going to allow a shareholder to sue him for that. But I think it at least raises the issue. I think he opens himself up to shareholder liability unless he says, I'm putting batteries in Puerto Rico because I'm hoping that they'll appreciate Tesla and it'll improve the goodwill of the company and we'll sell more cars. I mean, that helps. If he says we have a responsibility to serve our community and, he wants to do it, that's neutral. If he went ahead and said, we're going to put batteries in Puerto Rico because my shareholders are too rich and these stupid venture capitalists don't deserve it, I think he opens himself up to a lawsuit just the same way Ford did. I don't think he's as stupid as to say that, or maybe maybe stupid is the wrong word, but like Ford had this vision of himself that was brazen. That's a good word for it, right? He was really brazen, and he would say things. I mean, I got more too. I mean, really, after all this urbanization, after all this, it turned out he hated more than anything the suburbs. The suburbs, which exist primarily because of the automobile that he developed and made popular and made available. The car is what makes the suburbs possible. And he hated the suburb. He hated it so much that he bought a huge chunk of land and built basically an imitation of where he grew up and lived out the rest of his days in this kind of fake 1890s farmland within Chicago that he had built. It still exists today. You can still tour it, right? And he wasn't a particularly nice guy to his kid either. His son, who took over the business, died of stomach ulcers and apparently was berated by his father constantly. There's some, and for a socialist, he was also very anti-union. He hired thugs to beat up union representatives. There are pictures of union representatives with, broken noses and bloody faces coming out of strikes at the plants. So, anyway, there are books on the guy.
Is that historical background that wasn't in the text, and I think is extremely important, it probably should be in there, because that makes a difference.
I think it makes a difference. I don't think you can understand Ford without understanding all that. So.
He was really a socialist.
Well, he believed in distribution of wealth in a way which accords with socialism, but at the same time, he believed he should be the one to do it. So he was more of a national socialist, right? I mean, he believed in this sort of communalism so long as he was in charge of doling it out. And he believed in culture so long as he was the arbiter of what that culture was. So I think in a way he was, in a way he wasn't. I mean, people will debate whether the National Socialist Party was socialist. They had an aspect about that, but they also had a totalitarian aspect to it as well. And he seems to accord with that philosophy, at least enough to have some mutual affinity there, philosophically, if not otherwise. All right, to more mundane issues. Can corporations give charity? The answer in a nutshell is yes, they can. That corporations generally are permitted to give charity, but this reintroduces issues about duties versus power, whether there's an obligation to give charity. Does Tesla have to put batteries in Puerto Rico, or are they permitted to put batteries in Puerto Rico? The discretion of management, and how to deal with the conflict of interest that are inherent with this. So why should corporations be allowed to donate money to charity? Tax deductions? But why give tax deductions? Why encourage it? Yeah.
Because corporations have the most money to dispense to things like charitable causes.
So they have the money. And so if we don't, for one social concept here is that if corporations don't do it, who will? Because this is where the money is in America. Yeah.
But the pure capitalist argument against that is that the shareholders themselves will, that the corporation, not being a person, wouldn't do that, but the people in control of it.
Yeah, let's make money. So the counter argument is let's make money for the shareholders. I mean, this is also a similar argument, and this is not that class, about should the government redistribute money, or should it not take that money in taxes, and people will give that as charity. I mean, that is like a viewpoint, right? That, if you believe in tithing, you should be giving 10% of your money to charity. If the government takes that money out of your paycheck, you're less able to do that. So this is sort of like that discussion in tax law. Yeah.
One question, it said in the book earlier that Friedman's favorite gentleman here mentioned to resolve market failures. Does that mean as far as like corporate bailouts? What does that mean?
Yeah, so, okay, market failure. Market failure is a term used anytime the government wants to intervene in a market. So a market failure in economics terms can mean a number of things, but usually it refers to a monopoly, where one company gets dominance or control. And if I had some more time, I can walk you through it. You've probably seen the chart. You got your usual supply and demand chart, and then price is where they intersect. And then you move your supply curves and your demand curves, and the price moves, and that's price theory. That's Milton Friedman. But there's also a condition where the price is not where supply meets demand. But when there's a monopoly, the monopolist can set the price independently. And what will they set the price at? They'll set it at a different place. They'll set it where marginal cost equals marginal revenue. And the problem with that, if you saw the triangles, the corporations with a little bit more money, but there's a lot of product that's not sold, and a lot of people that paid too much for the products that were sold, and so it's what we call deadweight loss to society. That's your classic market failure, where you have some kind of monopolist. But there are other types of market failures, and people talk about like the banks and needing intervention there. So, all right, so corporate charity, yes, it's allowed, and in fact, in the Model Business Corporations Act, Section 3.02, it's specifically authorized. The language here is that unless the articles specify otherwise, so this is a default provision. It's not mandatory. The shareholders could say, nope, no charity. But unless the articles provide otherwise, every corporation can give charity, including without limitation, power to make donations for the public welfare or for charitable, scientific, or educational purposes. This is a default provision. It can be limited, but it is fundamental to know that, in general, corporations are permitted to give charity. And we have a case for that. So this was the case of Theodora. So, getting a little short on time, so I'm going to give this one a little less attention. But basically, in this particular case, we have Gerard Hansen, and he had a lot of shares of stock in a company called Alexander Dawson, Inc., which he transferred to his wife, I guess ex-wife, as they were getting separated. Part of their separation agreement, she got some shares. So now she has these shares. She forms the Theodora Holding Company, and in this holding company, she puts these shares that she got. And Mr. Henderson was a major shareholder. He had dominated the company. And while he dominated the company, he caused Dawson, the company he dominated, to give charity. Right? As I said, he's a major shareholder, so he controls it. Right? We saw with the straight voting example. You own 50% plus, and this guy was, benevolent. Assuming this is like legitimate, nice charity, which it seemed like it was. This is the George Junior Republic. It's a camp for underprivileged boys. Seems like a nice thing, and he was given. This is 1969, $60,000 to $70,000 to this charity, which, by the way, he had formed every year, and a large tract of land. But one of the directors, which was appointed by his ex-wife, now, by the way, people who get divorced don't always like each other, and sometimes that's part of the story too. So we have a former couple, now divorced, where they're both significant shareholders in a company. Can you see the problem? Okay, so kind of easy backstory on that one, and essentially she sues and says that the corporation should not be giving charity because this charitable giving is not connected to the business. It's nothing to do with the business. Why are you giving money to a bunch of underprivileged boys? That has nothing to do with improving our bottom line. And the question here was, can the company give charity even when it's totally unconnected to the bottom line? And the answer was yes, because the gift was reasonable. Okay, so obviously the action is why the court found the gift was reasonable. Why was this a reasonable gift? The court introduces in Theodora the reasonableness standard for charity. So you need to know from this case that a corporation can donate money to a charity unconnected with the corporation's business so long as the gift is reasonable. Now, I teach contracts, and reasonable comes up all the time. It's a frustrating word because it means you have to consider all the facts and circumstances, and it also means, as your professor, I can't tell you right now what reasonable means in all concepts and in all senses all the time. What was reasonable in this point? Well, here it didn't require the company to give up huge amounts of its assets. So the gift was made in a year that the company made $20 million, and the gift was $528,000. So the first factor that this court analyzed, and this is a factor, but not the factor, was that it was a relatively small percentage, about 5% of their income, and to Paul's point, it was within the federal tax deduction limit. So this has become seen as standing for the notion that corporations can give up to their federal tax deduction limit and be within a sort of safe harbor of reasonableness. This was certainly within that limit. And in providing for those in need, the gift benefited the company in the long run, they claimed. They actually claimed that this had a wealth maximization concept, justified for large private holdings. So the court goes through the analysis on there. It's a classic case, the Theodora Holding case, and the rule that emerges is that corporations have the power to make charitable gifts, and they fall under a reasonableness test, and the way you pass that test are not it being a big portion of total earnings, whatever big means. In this case, 5% was okay. Certainly within the federal tax deduction limit, that really helps it look reasonable. And if you can come up with an argument that it's in the long-term best interest, even better, even better. So yes, corporations can give charity, but it is not unlimited. If they gave, let's say they gave 95% of the earnings that year to charity, that may not look so good, right? Elon Musk can't give all the corporation's money to science, but he could give some. So we've seen that directors can make charitable gifts, even those that are unconnected. But why are the directors making the decision about what happens with the shareholders' money? Shareholders have often proposed charitable giving. This, by the way, is a meeting of shareholders of Walmart. Looks like a party, actually, right? I mean, this is huge. What is a stadium, right? I mean, we've got tens of thousands of people here. And there are millions of overall shareholders. Some large institutions, some might be some of us in this room. So should shareholders be given more role? This is another topic you might look at if you're interested in this, right? Should shareholders have a voice in what the corporation donates to when it's outside of the business purpose? Two professors, Victor Brundy and Alan Farrell, proposed that they should. That was Brundy, B-R-U-D-N-E-Y, Brudney, and Farrell, F-E-R-R-E-L-L, if you're interested in that being a research topic for you. They proposed that shareholders should have a greater role in corporate charity, and the board should set aside money for charity, and then the shareholders should vote on where that goes. Sort of an interesting inversion of the usual balance where the directors decide what the corporation does, but in that way the decisions would be based on morals and preferences, and the directors don't have any type of monopoly on morals or preferences. They're not the moral arbiters, they're simply the financial arbiters. And so Brudney and Farrell in Corporate Charitable Giving, 2002, that was 69, University of Chicago Law Review, 1191. I'll post the link on that as well. All right, and one more concept here, which is the concept of greenwashing. So all this talk about CSR is nice, but as I pointed out, every rose has its thorns, and you don't know what are the true intentions of a policy. I'm not so convinced corporate social responsibility actually exists at all. I don't know that corporations actually do this. I don't know if they just are dressing up social responsibility in a green wrapper. And so I ask whether or not CSR is really something that exists at all, or whether a lot of it, or most of it, or all of it is what is called greenwashing. And greenwashing is where a company or organization spends time and money presenting a green message, and that's been broadened. That used to be eco-friendly, Captain Planet and all that good stuff, and now it's expanded to include things, all sorts of things. All sorts of things. And, you should look at that. I mean, when Nike supports Colin Kaepernick, are they really supporting a social movement, or are they trying to sell shoes? Right? What are they actually doing? Now, in nature's infinite book of secrecy, little I can read. I don't know what is in the hearts of directors and the minds of directors. I only know what they are projecting, but I know sometimes it really comes off a little thin. So let me show you this video. Oop, don't want to skip ahead. Because to me this really sums up greenwashing.
Fiji water is a gift from nature to us, to repay our gift of leaving it completely alone. Bottled at the source, untouched by man. It's Earth's finest water.
All right, Fiji water, okay? That advertisement, I think, makes Fiji water look pretty green, right? I mean, you look at the imagery there, and you've got a lot of natural imagery, and you've got a lot of aspects there that might make you feel good about buying it. Well, a couple facts I just want you to know about Fiji water, right? And I'm short on time. This is usually a fun discussion topic. But since I'm short on time, just a couple facts about Fiji water. 1/3 of Fijians, which is much more than the 1/10 of people in the world, don't have access to drinking water that's safe. So in this beautiful island nation, which has this beautiful untapped aquifer, where they can literally airlift heavy bottles of water to your 7-Eleven, the people there have less access to potable drinking water than in the rest of the world. And not only that, but the government tried to impose a tax on Fiji water, saying, we need you to step up, and we need you're tapping into our natural resource and exporting it at your profit, and our people are dying of cholera, right? Like the Oregon Trail. And remember that game? Dysentery. Was it dysentery? Cholera, dysentery? So they tried to put a tax on it, and Fiji Water said, if you tax us, we're leaving Fiji. We're going to keep the brand Fiji Water, and we're just going to pump it out of the Chicago, whatever, like what Dasani does, right? Like, I mean, if you buy Dasani water, you're basically drinking purified Pittsburgh tap water. You know that, right? Which is okay in the sense that it's fine. I mean, it's fine. It's water and it's convenient. I'm not saying it's a problem. I'm saying the problem is when you make it out like you're out there trying to save the world. To me, this is the prototype of greenwashing. Making people feel good about themselves and buying a green product where really the product is taking water from people that are too poor to even afford clean water. And, I mean, and you look at this advertisement. I mean, what is this trying to say? That Coca-Cola is like good for you and like the environment? I mean, it's not, guys. I mean, it's fine. Coke is fine. I don't have any problem with Coke, Coke. But it's not good for you, and it's not green. It's made out of glass. It takes energy to produce, and it's soda. So, this is what I mean by greenwashing. And these are the obvious examples. But I invite you to look for the subtler examples. Yeah?
How about Domino's Pizza paving roads and all these commercials are like, hey, tell us about your potholes, buy our pizza.
Yeah, so, I mean, and then they actually spray paint the Domino's logo. And by the way, I signed up for that because my street is awful. So I was totally fine with that. But I think that's a great example. Are they really helping out, or are they getting free advertising? Yeah.
I did a seminar on corporate social responsibility in college, and one of our projects was to look at company websites to see if they were greenwashing. And you can almost take a boilerplate statement from all these different companies, and it says almost the exact same thing on all their websites. It was really funny to see.
Yeah.
You're not doing this. Everyone's saying the same thing.
Yeah, it often has life and planet, and it's always green colored too. I mean, there is a lot of science to this. I mean, McDonald's is red because red makes you hungry. Those red and yellow colors are supposed to make you hungry, make you eat more. And green, I guess, makes you happy and want to spend money. I'll trade my green dollar bill for a green Coca-Cola, and it's like I have the same thing. But the more you look, the more you see this. And the more you see this, I think you start to really ask yourself, is CSR a real thing? Or is this really what's going on in corporate America? I mean, are we all just fooling ourselves and saying we should authorize directors to act for the social good when in reality they only pretend to and they never do it anyway? I don't know. I think there are some cases of real greenwashing. I think if I can be blunt about it, that there's a lot of BS out there, but it's not all BS. I mean, there are some authentic things, and it's not that corporations never look out for society. But like I mentioned, in the case of Elon Musk trying to put his batteries in Puerto Rico, I mean, that was blocked. I don't know why it was blocked, but maybe it wasn't so good for Puerto Rico. Maybe it was a marketing stunt, and maybe it wasn't such a great idea. Maybe it wouldn't have helped. Maybe it caused some other hazard. Or Domino's, coming and paving my streets. I don't know if they're going to do a very good job, but I know they're going to have that pizza logo on my street for the rest of my life. So I think we need to be wary about corporations, and in particular, lawyers. So kind of the last element here is, what about you? So you may or may not, care about investing in a company that's socially responsible. You may or may not care about drinking Fiji water or whether your Coke is green or red. But if you get a job in corporate America, this aspect will come up. Attorneys advise shareholders and they advise management in the most important decisions that companies make. So is there some responsibility for you as attorneys in the corporate world to represent these parties in a certain way. And there are three approaches that have been presented by three different individuals. I'm just going to run through them and then wrap up. And those three different viewpoints are that one, Justice Potter Stewart. These are just three ideas to throw out there to give you something to think about. But Judge Potter Stewart had the conception that lawyers are responsible for enforcing the morals of the marketplace. Be honest and competent, and don't go below the moral standard of, don't sink into the mire and be worse than the competition. Chancellor William Allen from the Delaware courts said, no, there's something more. Lawyers have also a duty of independence, that they have to think for themselves, and they sometimes have to show that personal integrity. And moreover, lawyers might have to walk away from a company when that company is engaged in inappropriate action or not taking care of society. And then Professor Richard Painter went a third step further and said that lawyers are actually interdependent with the companies that they serve. And as a result of that interdependence, the corporation's actions are your actions. When you represent a corporation and it does something that is underneath not just the standards of the marketplace, but your own personal standards, that it reflects on you. So I'll talk just a little bit more about what those three ideas are. I just invite you to think there's no law or rule on this. This is all about helping you think about who you want to be when you practice. So Justice Potter Stewart conceived of corporate ethics as sort of a minimum standard, a basic level of honor and professionalism. Keeping the trust of your clients, don't bold-faced lie, don't commit fraud, and try not to embarrass the legal profession. Right? It's a very minimum standard because, the goal of corporations is to make money. It's a ruthless world. We're not here to impose higher morals on our clients. We're just here to serve their interests. So lawyers, according to Potter Stewart, who wrote the book Professional Ethics for the Business Lawyer, said that lawyers should do no more than observe the morals of the marketplace. There's no special additional duty. But Chancellor William Allen said that lawyers do owe a duty of independence. Independence, the lawyer's duty to the legal system itself. That lawyers are not just part of a corporation, but part of this law environment. And as a result, all of us entering into this profession have a duty both to our clients and to the profession. And that duty to the profession would sometimes require us to zealously advocate for our clients and sometimes to walk away from a client we can no longer represent. That our duty to the profession is sometimes higher than our duty to our client, and you should not besmirch the profession by engaging in conduct that is merely at the morals of the marketplace and not what a lawyer should be doing. And finally, for those who want to go farther, you can read Professor Richard Painter's The Moral Interdependence of Corporate Lawyers and Their Clients, who actually says that no, you can't walk away. You have to raise that client up. You are not independent. You are interdependent. And according to Professor Richard Painter, there's actually an affirmative obligation to encourage and bring your companies to a higher ethical standard. That lawyers have a special role to play in elevating the morals of the marketplace to a higher standard. I don't think there's any one particular view, but that I would say you have to adopt, but those are certainly things to think about in defining for yourself what kind of lawyer you would want to be. All right, so let me just conclude on what were my main points. I rambled on for a while, so you probably need a little recap. All right, number one, corporations are sometimes seen as private property. In fact, they're always seen as a type of private property, but this type of private property has a social function as well. And corporations only exist because society allows them to exist, and the modern corporation under modern statutes has the ability and maybe the obligation to pursue some corporate social responsibility, to have some morality and some ethics. It's not just your house where you can prevent anyone from entering, but it exists by a special lease from the government and you owe something to it. But that said, as we learned in Dodge versus Ford, you have first and foremost an obligation to your shareholders. You cannot bamboozle your shareholders for the benefit of society. And in fact, I think that case is implied that it says more than it does. It really is. It's an important case to understand, but it's not a case to cite. I mean, it was really It's really a one-off kind of situation. You'd have a person like that. But, once in a generation, we get an experience like that. And you see how the effect of charisma impacts the ability to fundraise. And then you have this big personality with a huge amount of control. I mean, what's Ford without Ford, right? He wasn't exactly someone you could depose easily. In the case of Ford, what do you take away from it? The court did order payments of the dividends because otherwise he was going to essentially waste the corporate assets. And that was really, he couldn't just throw the money away. If he had the money, he had to give it to his shareholders, fine. But the judges did not force him to enjoin and stop his expansion plans because, quote, judges are not businessmen. The business judgment rule still applies. We know that charitable contributions are okay. This is Theodora. The Theodora case stands for the notion that charitable contributions are okay so long as they're reasonable. Okay, we don't really know what that means exactly, but if it's a small percentage of annual earnings and it's within the federal tax deduction, and especially if it can be linked to long-term value, cool, you're good. And this greenwashing concept is real. I mean, I'm not so sure that we need to have such a conversation about CSR because I'm not sure companies really pursue it. I mean, they've learned from Ford, and Ford at least stands for this. Don't say that the purpose of this is to throw away money. Say that the purpose is to maximize shareholder value. Say that the purpose of not having, as we'll see a case, Schlensky versus Wrigley. We'll go back to Chicago for that case. Fun case, right, about the Cubs. And what's that case about? The Cubs didn't have night baseball. They didn't have night baseball, and the owner, Wrigley, said, I don't want night baseball. It's going to diminish the value of the neighborhood. That's not what baseball is about. And they didn't install lights. They didn't put in night baseball. And he was sued, but he won. Why did he win and Ford lost? Stay tuned for the answer to that one. What was the difference between Ford and Schlensky when we get back to the duty of care? Why was that a business judgment and this wasn't? Might have had to do with the message. But that said, I'm not so sure that what they're really doing is that legitimate. So you need to decide for yourself what role you're going to play in this. I mean, if you step into corporate America, you can meet the minimum standards of the morals of the marketplace, and you probably won't lose your license. But is there some obligation you have beyond that to either walk away from a company that you just can't represent, or even more, to get involved in a company, become interdependent with it, and raise it up to a higher standard, what I hope is a professional standard, not forgetting that the law is a profession. It is a business, but it's also a profession. And built into this profession is corporate or personal social responsibility. So, thank you.